Hello and welcome to Talk to Al Jazeera. I'm Sami Zeidan. In the wake of the September 11th attacks in 2001, US President George Bush created the Office of Homeland Security. It was renamed the Department of Homeland Security a year later. Well, according to its own mission statement, the department seeks to prevent and deter terrorist attacks and also to protect against and respond to threats and hazards to the nation. Well, to undertake that task, the department now has over 200,000 employees. With me today is the man in charge, the Secretary of Homeland Security, Michael Chertoff. Thanks very much for talking to Al Jazeera.
I'm happy to do it.
7 years after the September 11th attacks, what are the main threats to the U.S. mainland?
Well, we still look, of course, at the possibility of international terrorists traveling to come into the United States and carry out the kinds of attacks which were carried out on September 11th, which were attempted to be carried out, for example, by the shoe bomber later that year, and which were attempted in 2006 by a group of terrorists who attempted to board airplanes in the United Kingdom bound for the U.S. and to blow up those airplanes. So we're still focused on international terrorism.
Some say it's time to end measures that disband normal civil liberties in the United States. Do you agree?
Well, I'd have to say that I don't think we've taken any measures that actually do disrupt normal civil liberties. Obviously,
measures such as detention without trial or charge, terming foreigners enemy combatants, denying them of POW status. I mean, there's a lot to talk about and argue about if you wanted to.
Well, if you look at, first of all, activities within the United States, with literally just a couple of exceptions, people who are apprehended in the United States are charged in the criminal justice system and go to trial like everybody else does, with lawyers and the full protection of civil liberties. People caught in the battlefield in Afghanistan and other parts of the world, as has traditionally been the case in war, obviously don't get criminal trials, but go through a process where they ultimately get some kind of military adjudication.
Let's take some specific examples. People like Ali al-Marri, who's been held now for 5 years, still not facing any charges, let alone a trial. Isn't that a real shame for U.S. justice?
Well, actually, so you've picked one of the two cases where someone was apprehended in the United States. In that case, I have to be careful because it's a pending case, so I can't be specific. It began as a criminal prosecution, then it became part of the military system. There is a military justice system that applies in time of war, and they're in the process now of moving forward with these military commissions. And I might point out that they've got lawyers who are very aggressively and vigorously defending the people who were accused.
Well, the litigation is on the point of whether a U.S. resident can be stripped of constitutional rights. He's not facing at this point charges related to terrorism.
Well, I think the question is, can he, a person who's in the United States lawfully, not a U.S. citizen, obviously, can that person be brought into the military system if there is a basis to believe they are at war with the United States? And again, this is, I don't want to get into the facts specifically, this is an allegation. So he's testing the question, and that is the very matter before the courts. And what people sometimes overlook is, when the court says, for example, that a particular measure does violate the Constitution, then the government obeys the courts. When the courts say that, in fact, a measure is consistent with the Constitution, then they've upheld what has been done. And the Supreme Court has actually said that there is power that the government has in time of war to detain people as combatants and as enemy combatants pursuant to the Constitution. That was the Hamdi case.
Some would argue that actually what U.S. authorities are doing is playing with the rules. And in the case, for example, of al-Marri, as you mentioned, he was facing charges, I think credit card fraud, nothing related to terrorism. In the civilian court system, before that was supposed to come to court, he was then termed an enemy combatant, losing his rights under the civilian court system. In other cases, the opposite has been done, such in Jose Padilla's case. He was termed an enemy combatant, and just before the courts were about to rule on whether that was lawful, he was then put back through the civilian court system. Where's the rule? Where's the consistency here?
So let's begin by pointing out that Padilla was then convicted in court by jury. So in fact,
in the civilian court system, though.
Now, there is actually no rule that you have to pick one or the other. If a person does something which violates both civilian law and the law of war, and it's certainly possible to violate both, the government has the ability to choose either one of those, or frankly to choose both.
The situation between military tribunals and the civilian court system is very different, as you know. The right and the limitation on how long you can be held, whether you can be held without charge. Those are very real differences. We're not talking about a federal versus or one country system versus another. This is a very different system of trying people.
Of course there are differences, and it makes sense because in time of war, you're not going to immediately rush people to a magistrate. I mean, let's talk about World War II, for example. When we were at war with Germany and Japan, and people were caught on the battlefield, they didn't get lawyers immediately and then go to trial. They were held for a period of time, and there are ways in which their position is adjudicated. And those are the same principles that work here. But here again, Sami, let me just remind you, all of these, and this is really the kind of the end point, all of these issues are and have been challenged in courts. The courts upheld some of them. Sometimes the court doesn't uphold it. Whatever the court decides is then obeyed by the government. So everybody has access to the process. Are they all happy with it? No, but I've never met a person who was charged in any court or held in any circumstance who was happy with that. The key is they do have the ability to contest it and ultimately to go to the Supreme Court.
The fact that convictions through the civilian court system have been obtained, like in the case of Padilla and Moussaoui, doesn't that prove that these extraordinary measures are not really necessary? It's not necessary to strip people of either their constitutional rights or their rights as POWs.
Well, I certainly agree that the criminal justice system has worked well and is appropriate in a large number of cases and has been used and should be used. At the same time, again, it's been traditional that when people are, for example, caught in the battlefield in Afghanistan, just as when they were caught in the battlefield in Europe during the Second World War, you don't put them into a civilian court. When we caught German soldiers during the Second World War, they didn't get immediate criminal trials with juries. They were held as prisoners of war. That's, again, it's been in the system of the law of war.
But the U.S. isn't doing that. You've termed people enemy combatants. They're not being held as POWs under the full protection of Geneva. Let's be very clear.
That's correct. And so if now someone is in the field of combat and apprehended in the battlefield, and they violate the laws of war, they don't wear a uniform, they don't obey the various rules of war, then they are not in the same lawful status as a prisoner of war. At the end of the day, all of these people have raised these issues in actually civilian courts. The courts upheld a lot of what the government has done. When the court has said you can't do that, then in fact the government obeys the court.
A short question. Do you believe that the U.S. president should have the powers to detain U.S. citizens and residents without charge for an unlimited period of time?
I don't think anybody contends that a president just has the power to detain people without charge indefinitely with no kind of process.
But that's what the U.S. is arguing for in the case against al-Marri. It's for that principle, that the U.S. president should have the power to detain residents.
Well, I think the Supreme Court's already held that the president and the executive branch does have the power to detain people as part of war fighting or as part of a military struggle under the laws of war. And what the court said in Hamdi is, now there has to be some kind of a process. It's not just that it's done on the say-so of an executive official. What that process has to be is in fact what is at the core of all of the legal battles going on now. What kind of legal rights do they have? What kind of legal access do they have? And again, the very point you're making, I think, confirms my position, which is these individuals have lawyers. Lawyers are raising these arguments. They're getting heard in court.
But
now,
what's your belief? I understand the process, but what's your belief? Ultimately, should the president have the ability to detain residents without any limitation, without charge?
My belief is that the government does have the right to detain people in time of war as a protective measure, but that there has to be a process in place to determine, to review that decision, to make sure that the facts, in fact, support that detention.
Who would make that decision? Who would review the president?
Certainly, it's not so much reviewing the president. The president is making a general determination. Obviously, individual cases are usually pursued by individual executive branch officials or military officials. And in that circumstance, what should happen is whether it's in an independent military tribunal or whether it's in some kind of other tribunal, there has to be some way to test that by an official or an adjudicator who wasn't part of the original decision and who can take a dispassionate look at the facts. Now, that's the process they've established in the military system now for dealing with these individuals. And, you know, whether it's a perfect process, whether it should be refined, I think that's, in fact, at the heart of the debate we're having now. But I think the general principle that there should be some review in some tribunal, whether it be military or civilian, I don't think anybody would really dispute that.
All right, well, we're going to take now a short break. We'll have more with Secretary Michael Chertoff. When we come back, do stay with us.